We will go on the record in the matter 26 CF 35, State of Wisconsin versus Leon Chapman. The state appears through District Attorney Kevin Schmidt in person. Mr. Chapman appears in person with his counsel, Daniel Chapman. We're set today for a status. Mr. Chapman, can you please update the court?
Your Honor, I have the discovery and I believe I had an offer too, but that was a while ago. The issue here is there's a prior conviction from North Dakota that I have been able to confirm that there was no attorney for, but beyond that, I'm going to need to request a transcript. There's also a possible stop issue that I discussed with Mr. Chapman today, but if I file that, I'll file it at the same time as the collateral attack motion. For now, I would just ask for another status hearing.
What year was the North Dakota?
One moment. 2011.
Okay. I don't know their retention statute or policy, but
We will see.
all right. And so how long do you think you're going to need?
If you give me 2 months, Judge, I'll know by then.
I can do either various times. I'm pretty open in the morning and a little open in the afternoon on August 3rd, or I have a few time slots on August 5th.
Looks like I'm already in front of you the afternoon of August 5th. Could we do it sometime then?
When are you in front? Oh, I just pulled you up at 2:15 to 2:45.
Also 1:45.
1:45, and that's plea and sentencing. And plea and sentencing. Why don't we do 1:45? We'll quick do the status and then we'll move on to the plea and sentencing
Thank you.
on August 5th. You can come get your notice and you are free to leave.
Is it 2:45?
That's still your number?
1:45.
Oh, yeah, thanks.
Do I have
I'll be in touch before
Jonathan
then.
Lowry or Byron Benjamin? Or are we gonna go right to Mr. Morales?
Lowry is here. I haven't even looked for Mr. Benjamin yet. He's not until 11:30, I thought. But isn't Mr. Morales at 11?
He is, yes,
Okay.
I was just wondering. And I did actually do a written decision, but I haven't filed it yet.
Just have to make sure this is the right one.
Finished it yesterday. So I just need to. Oh, there you go. Yes,
Don't see Mr. Benjamin yet.
okay, Mr. Morales. In 1 second. Oh, shoot. Sorry, 1 second. Oops. We will go on the record in the matters 26 CM 32, 26 TR 04, and 19, State of Wisconsin versus Anthony Morales. The state appears through District Attorney Kevin Schmidt in person. Mr. Morales appears in person with his counsel, Daniel Chapman. We're set today in this matter for a status conference. We had a suppression hearing not too long ago. The court did take it under advisement, and I have now uploaded and signed my order, my suppression order. So I'll go over it very quickly with you, but it is in more detail in the decision. The court here's the thing, there were certain findings that the court did make. That on January 1st, 2026, during the daytime hours of New Year's Day, approximately 12:07 p.m., the arresting officer responded to a single vehicle accident. Upon arrival, the officer observed the defendant's vehicle resting on the roadside ditch, stuck in the snow. One of the tires was continuing to spin or rotate. No other vehicles were involved in the accident. Upon making contact, the defendant was a sole occupant of the vehicle. The officer stated and testified at the suppression hearing he observed multiple signs of intoxication, including a strong odor of intoxicant emitting from the defendant's breath, glassy and bloodshot eyes, and the officer testified that his speech was slurred or somewhat broken. In response to questioning from the officer, the defendant admitted to consuming alcohol and stated, well, it was New Year's. So he had alcohol. He did not want to perform the preliminary breath test. So the officer asked him to perform the standardized field sobriety tests. The defendant complied and he performed the test. We watched this on video. He passed all of the tests or shown only minimal signs of impairment except for the HGN, the horizontal gaze nystagmus test. The court does find, after watching the video and observing the officer perform that test, and with the exhibit provided by Attorney Chapman for the National Highway Traffic Safety Administration guidelines, the court does find by this viewing that the HGN test was not performed accurately or properly. The court did review the legal standard for probable cause for an OWI and the test of the totality of the circumstances. In reviewing this and the impact of the inaccurate or incorrectly applied HGN test, the defendant does argue because that test was improperly administered, and because he did pass the other field sobriety test, the other indicators of impairment are legally negated. But however, Wisconsin law does explicitly reject this. The court did view the case State v. Felton in reviewing this, and there the Court of Appeals held that a driver's successful performance of roadside field sobriety test does not cancel out, erase, or subtract from other compelling independent evidence of intoxication known by the officer. The court cannot confirm whether or not there was bloodshot eyes or glossy eyes, or whether or not alcohol was emitted from the defendant's breath. That is an observation that the officer must make in the field while observing the defendant. The court did have the ability to review the field sobriety test, the standardized field sobriety test by the video, and the court does state that because of the failure to administer them properly, the HGN test does not come into play and is excluded from the assessment and the determination because it is a flawed test. So that so it cannot be used to support a finding of probable cause. However, in reviewing all of the other factors and all of the other cues that the officer did see with regards to this matter, the fact that this was a single vehicle crash into a ditch, the noon hour on New Year's Day, which is a holiday that is heavily associated with alcohol consumption. The weather was snowy, but it was not snowing at the time. It was bright and sunny. No snow was falling. However, the defendant was indicating that he did admit to drinking alcohol, and the officer did have a strong odor of alcohol, glassy eyes, slurred or broken speech. Therefore, based upon that, the court does find that a reasonable officer, considering all of these factors together, would still form a reasonable belief that defendant and his ability to operate a motor vehicle safely was impaired. While his performance on the physical test, even the court viewed him performing these tests, him doing this suggests that he may have a high physical tolerance or a high level of physical coordination. It doesn't override the substantial physical or other behavioral evidence of intoxication witnessed by the officer. Therefore, based upon those reasons, the court is denying the suppression motion. So we do need to figure out where we're going with this matter now, Mr. Chapman.
I'd ask for a status conference to give me time to discuss that with Mr. Morales.
How far out would you like?
I don't need 2 months. I'm in front of you on the 24th at 3.
June?
Yes.
Okay, if you want to come June 24th at 3, that's fine.
Yeah, I've got a plea and sentencing here at 2:15. So
Oh, what? Let me just pull that up. June 24th.
Thomas Toll.
June 24th. At what time are you here?
Well, my calendar is actually a bit odd. It's the physical image on my calendar is marked at 3 o'clock, but the text in the entry says 2:15.
I don't have you on 2:15.
So maybe it got rescheduled.
So you said Toll?
Yeah, TOWLE.
Yeah, I know Mr. Toll.
Well, I could make an appearance at that time either way. If I'm not coming here for something else, I would appear by Zoom.
That is scheduled for August 5th at 1:45.
Yeah, it looks like I just forgot to take the old one off my calendar.
I can do your July 20th at 1 unless you want it earlier.
No, that's fine.
So July 20th at 1 p.m. We'll have a status. All right, you can come get your notice and you're free to leave.
I have
Mr. Benjamin?
at least one more case.
What?
And if you want to talk to me after I'm done, you can hang out there.
Or
Otherwise, just
do,
give me a
or
call
are
later.
you with Mr.
I can
Lowry?
hang out out there. for a
Okay.
little bit.
Lowry is here. I don't believe Benjamin
So we
is.
can do Lowry?
I'll go check the hallway and see if Benjamin's here.
Lowry is a CT.
Okay, I didn't even notice. Thank you.
I don't see Mr. Benjamin anywhere.
Mr. Lowry? We will go on the record in the matter 26 CT 18, State of Wisconsin versus Jonathan Lowry. The state appears through District Attorney Kevin Schmidt in person. Mr. Lowry appears in person with counsel Daniel Chapman. We're set for an initial appearance. Mr. Chapman, were you able to go over the criminal complaint with Mr. Lowry?
Yes, Your Honor. Mr. Lowry understands the charges and the possible penalties. We will waive reading of the complaint and plead not guilty to each of the 2 counts.
Not guilty plea will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Is he looking at the IDIP program?
He's actually already completed the IDIP program.
Oh, I think you said you were doing that some time ago. Well, that's excellent and that's great. So what are we doing? You just need time to review and do the
Yes, I need
things?
to get the evidence and review it, and assuming there are no issues with the actual evidence, we'll set a plea after that.
I don't know how soon you want to come back because I could schedule you for July 9th in the morning if that works.
Can we just use July 20th?
Let me go
Or
to
is that
And there's the key ruling. The judge is essentially saying, even though the HGN test was thrown out because it was improperly administered, the rest of the evidence still adds up. The crash, the odor of alcohol, the bloodshot eyes, the slurred speech, and the admission of drinking were enough to establish probable cause. So, what do you think? Should one flawed field sobriety test really be enough to derail an OWI case? Or does the totality of the evidence still tell the bigger story?